in 7. I'm in 7 for the appellant, and in 6 and 8, my lord, I am for one. I'm arraigned as one of the respondent, my lord. In 8, I appear for. The 7 is an appeal preferred by.
Now tell us the story.
May I just tell you, Lordship, that story? My lord, the brief facts.
I am opposing these prayers for any stay.
My lord, let me just crack open the egg, then my lord, let us see what happens.
Mr. Bhattacharya, you were for the writ petition.
Yes,
For the writ petitioners.
Well, may I take your lordship to the brief facts?
No,
Lordship,
just
not look into the papers.
MET 6.
7, you know.
MET 7. You will take up MET 7. MET 7 to the.
अच्छा एक क्यों एक्टर लिखे ना नोट लिखे ना तो
the last day and all that. Mr. I don't understand it. Asking for a GTO. What's the concept on this?
तो क्या हो रहा
Well, kindly see, kindly
है विकास रंजन भट्टाचार्य petitioners अच्छा अच्छा
I am appealing for secondary board, your lordship.
अच्छा Abhutosh Mujumdar representing the you are representing the appellants
in my lord, appellant in 7. That is Gorkhaland Territorial Administration.
and in 8 you are
My lord, I
respondent.
am respondent.
अच्छा respond GTA. अच्छा Mr. Mujumdar, you are appealing for
Appellants in item number 8.
appellants in item number 8.
Appealing for appellant number 6. Appellant at number 6.
ঠিক করে নিন ওনাদের থেকে
Well, I am appealing for secondary board.
Yes,
Item
yes.
number 7 and 8.
I am appearing for the School Service Commission with Supriya Dubey, item 6, 7 and 8.
So what
The defect is, my lord, I believe. Defect is limited to, my lord, non-filing of certified copy. My lord, we have taken leave of your lord. Yes, the only. Well, may I take your lordship a brief overview of the matter? Well, it is like this, my lord. In 1997, your lordship knows better than all of us. The School Service Commission Act was.
how can you vouch on that?
I can vouch on that.
I don't know
All
what
of us can vouch on that.
Yes.
So, School Service Commission Act was enacted. My lord, initially, there were 4 regions as provided for in the Act under Section 3 of the Act. Namely, my lord, Northern Region, Southern Region, Eastern Region, and Western Region. Now, my lord, by a notification dated August 9, 1999, a separate region was carved out, namely, my lord, the Hill region, specifically for the districts covered or under the jurisdiction of the then, my lord, Darjeeling Gorkhaland Hill Council. Well, a regional commission was established accordingly for this region.
On 9th of August 1999.
Yes, subsequent to 9th of August 1999. In 2003, the state government, in its own wisdom, suspended the regional commission for Hill region.
Yes.
Since 2003 till 2024, there was no regional commission for Hill region.
For Darjeeling Gorkha.
Yes, for this region. For this region, it was under, the lordship may know, the DGHC Act was enacted in 1988, which was, substituted by repealed, and new act was brought into play, namely the Gorkhaland Territorial Administration Act 2011. So, the region which was under the jurisdiction of DGHC is now under the jurisdiction of GTA, and if I use the acronym, since 2011.
Hmm. Yes.
But since there was no regional commission, no regular process of recruitment could be undertaken or was undertaken for this region for last 2 decades. Even now, there is no action on the part of the state or the SSC to carry out any regular recruitment process.
No, what was the scenario prior to 2023?
2003 to 2024. We are talking about 20 years now. It's a
Suspension was on
2003.
No,
From
what was the scenario prior there?
Prior there to, my lord,
There were 4
one
regions.
process was undertaken. Your lordship is perfectly right. There were 4 regions. From 1999, it became 5 regions. So from 1999 to 2003, I will stand corrected by any of my learned friend. A process was undertaken for recruiting teachers. That is prior to 2003. The process was, my lord, made by agitation. Court cases were moved and appointments were given to some teachers. So this is all prior to 2003. We are now concerned with the period from 2003 or classically from 2007 to 2016. From 2003 to 2024, there was a complete inertia on the part of the state to take any action.
So during this phase, there was no recruitment.
No. Indisputably. Nobody can dispute that. Nobody can dispute that. Classical case of 20-year inertia akin to, my lord, if I may use the expression, Rip Van Winkle. Even the period matches.
Yes.
Then, my lord, what happened? Obviously, my lord, the schools which were running in this region, about 92, 94 schools, my lord, they started inviting applications from local youth. These local youth were otherwise graduate or even some cases postgraduate. But at that time, when they were appointed as volunteer teachers by the schools, they did not possess the B.Ed qualification. I am making it very clear. Some of them had. What the number? 50, 60, I am told. No, I'm not joining any issue here. It may be 2, it may be 50, but most of them did not have. Let us be very clear about the facts. So for last 2 decades,
so their engagement was from
by the schools.
From 2003 onwards.
No, 2007, the judgment records from 1999. What we are concerned with right now is about 313 teachers, those who were appointed from 2007 till 2016. That is, during this period, there was no SSC in the region.
So they were engaged from 7 to 16.
1999 to 2016. I'm sorry, 1999 to 2016. No. 2007-8 to 2016. 2007, 330. Till 2016. 2007 to 2016, 313 teachers. What happened?
No, they were spread over how many primary schools? They were
about 91 primary schools. Not primary schools. These are secondary, high secondary and high schools. We are talking
out of 313, all did not possess B.Ed qualification.
Yes.
Some possess.
Some there, but I do not have the figure right now. I should not be making any statement when I don't have the figure right now. But I am proceeding on the basis that these teachers, these local youth were appointed just, my lord, to tide over a crisis created by the state.
Yes.
Now, my lord, what happened? These teachers rendered service continuously without any break. My lord, an initiative was taken in around 2017. May I just give your lordship the exact dates? In the meantime, what happened? I must tell your lordship, several teachers moved this honorable court for regularization of their services.
Out of amongst 313?
No, other teachers. There are several teachers appointed all over the region. Now, my lord, these teacher, this honorable court passed several orders which your lordship will find. I am giving your lordship just the pages. Lordship will find those orders at page 395 to 587 of the my stay application. This is part of the state affidavit. About 83 cases, or I am giving your lordship the pages 395 to 587 and the orders.
Item number 7.
Yes, yes.
In item number 7, you are for GTA?
Yes, I am for GTA.
395 to 587.
I am told by Mr. Mujumdar that it is Mujumdar and Mujumdar this time. But this is Mujumdar and Mujumdar this time.
Yes.
So, I am told by Mr. Mujumdar that yes, some of the 330, but I will.
Then what happened? Then,
then obviously, in the basis of the orders passed by this honorable court,
some of them were appointed.
Regularized. Straight away regularized. Their appointments were confirmed. Now,
that is over and above. That is
over and above, over and above.
313 left out.
Yes. But I will come. There is another dynamics to this issue. And dynamics to the issue is that in the meantime, an endeavor was made by the GTA and the state to regularize the services of teachers. 439 teachers were identified in the region whose services were regularized. I pointed out that this present writ petition is not confined to the challenge regarding appointment or confirmation of services of 313 teachers. But this writ petition extends to 439 plus 313, which is, my lord, the figure would come to 752, if I am not wrong.
No, this confirmation was by order of the court or
No,
by the act of the authority?
The executive act.
Act of the authority.
Act of the authority. Absolutely. I am grateful to your lordship. I am so grateful. But and above this 439, about 100 odd teachers or something like that were appointed by orders of the court. So, my lord, we have 3 classes now. One class has been artificially created regarding 330 by this by the honorable single judge. My lord, these 439, when this list was identified and these teachers were confirmed, GTA pointed out to the state government that look, your list is not complete. Actually, there should have been 271 more. Well, the state government, through the district inspector of schools, the education department, carried out an exercise to identify who are the teachers who had been left out from the list of 439 who had been confirmed. It was our understanding that 271 candidates were left out, but the state, through its DI, came to a conclusion that 313 candidates were left out. This is where we get the figure of 313.
Yes.
Then, my lord, comes an order issued by the state government in the education department, which your lordship will find at page.
That is 8th March 2019.
Yes, 8th March 2019. I'm grateful to you.
Give us the page number.
The page number would be, just my lord, kindly give me a second. It is 673 of my stay application.
673. ওদের যে জিটিএ এর যে পেপার বুক ওই অ্যাপ্লিকেশন দিয়েছে ওই যে এটা দিয়েছে
Volume 5. Volume 5.
$673,
673, my lord. Page 673. Lordship will kindly take this particular memorandum. May I just read it out? Because these memorandums, I'm sorry, my lord.
একদিন বাকি এর মধ্যে যত ঝামেলা হবে
11th hour
আপনাকে ভালো কিছু চলে এসছে আমাকে ভালোবেসে চলে যাচ্ছে আপনার কাছে।
And 3.
Yes, my lord. Yes, my lord.
এই এটাতে একটু জল দিয়ে দাও না স্প্রিং। Yes.
Now, my lord, kindly may I just read it out? This is so relevant.
So the learned single judge has set aside this memo.
Yes. This memo, to the best of my understanding, serial number 2, but the order setting aside the memo appears to be, my lord, it's a lock, stock, barrel set aside.
So this was under challenge in the writ court.
This was under challenge because the writ court.
Achha, what was the prayer in the writ petition?
Still excellent prayers, my lord. This is the best part of the story, my lord. I am so grateful to your lord.
Achha, you will show us that first, please.
No, my lord, may I just take your lordship to the prayer. And I cannot resist the temptation of taking your lordship to
No,
the prayer.
we have to again go back.
Yes,
You
ma'am. Then
told
I'll kindly
me-
take 673. Then I will take your lordship to the prayers. Kindly take first, some of the documents. Kindly take,
673.
before I take your lordship to 673, I must inform your lordship. In 2010, my lord, when the DGHC, I mean the Hill Council, Darjeeling, Gorkhala and Hill Council was in power, it took a decision that no further appointment would be given to volunteer teachers. That forms one of the basis of the judgment. That a decision was taken long back in 2010 that no further appointment would be given to volunteer teachers. In 2018, well, now kindly take three documents. Well, because I, as an officer of the court, I am required to show your lordship all the relevant documents. It would be unfair on my part. I don't do that.
Make it a bit short, Mr. Moju.
Yes, but I am making it a bit short. Well, there was one memo of 2010 that don't appoint.
Date of that memo?
That is 30th July 2010. I am giving your lordship just the page.
Yes.
199. Lordship need not look into it. Nobody will dispute that.
This was by
This DGHC, deed and DGHC. Then, my lord, kindly take the next page, just the pages I am giving a lordship. On 25th of June 2018, before that, kindly take, my lord, 21, kindly mark this date, 21 to 2017. On this day,
page.
my lord, this is not with us, this is the cabinet decision.
Achha.
Well, on this day, the cabinet approved the regulation of services of a total number of 439 volunteer teachers who are in no way different from the pool of 330. This 439 is in no way different from the pool of 313. And my lord, I believe the writ petitioners will also not dispute that. Now, my lord, now kindly take, now the next date is 25th of June 2018. This is page 200.
25th June 2018.
2018.
That is page?
That is page 200 of the, my lord, this stay application. Well, on this day, a board resolution was taken by
No, challenge was this, you flow from this now, it will be, I
Yes,
think,
very good.
otherwise it be so many.
then, my lord, kindly take, my lord, 8th March 29.
Yes,
First.
place it before us.
Yes. Kindly take, my lord. The state has taken a decision. May I just take your lordship? With approval, various later issues related to education in hill areas of Darjeeling, Kalimpong districts. Kindly take, my lord, the first, the other three are not relevant. Kindly take serial number 2. The state government has taken a decision to regularize 313 voluntary teachers in secondary, higher secondary schools as communicated by DI Darjeeling to the Directorate Department by the order number so and so dated 2nd July 2018. So on the basis of this order, my lord, the appointments were regularized of these 313 teachers.
On and from?
on and from the date of the order. The respective orders were issued, and they were all these teachers. Subsequently, when Roma,
they were getting salaries from
the schools then, prior to the confirmation, they were getting,
after confirmation
after
from
they were-
19 they are getting
they are getting salaries from the chain of salaries somewhat different in hill region. Education department, GTA, then to the school. It's a route which has to be worked out in terms of section 55 and 57 of the GTA Act. Because the GTA was given under section 26, subject to any act, direction or order of the state government, GTA would have complete financial, administrative and executive power with regard to school education in hill area. That is provided for in GTA Act, in contradistinction to DGHC, which only had the executive power, not financial or administrative.
but financial burden is of the state.
Financial burden, it is partial, it is not completely state. The budget has to be placed. There is a planned expenditure, unplanned expenditure. Budget has to be approved, then funds are to be allocated. But there is a mechanism for that.
So they are getting salaries from 2019 onwards. Yes. Now tell us, it was challenged.
Now, kindly, before I take your lordship to the challenge, if your lordship
Take
permits
us to
me,
the order then.
the judgment.
No.
Yes. Kindly take the judgment. I will place the judgment. First, the prayers made in the writ petition. Because, my lord, this is an interlocutory judgment. Some of the issues have been left for the future circuit to take up. This is not a final, this is an intermediate judgment. This is a classical case of intermediate judgment. When one of the issues has been dealt with, other issues have been left to be decided by a next circuit or whatever circuit is available. And that is recorded in the judgment. So, by way of an intermediate or interlocutory judgment, the services of 313 volunteer teachers has been terminated. I am coming to the prayer straight away. Can you take the prayer? Page 117. I believe this will be volume 1. I have to read the prayer in totality. First, my lord, kindly come to just 3 paragraphs from the writ petition, nothing more. I will not read them even. Just first paragraph from the writ petition. First 2 paragraphs. At page, my lord, 88 and 89 of volume 1.
Yes.
My lord, the petitioner states that I will run through them quickly. The petitioner states that they are educated. My lord,
Yes, page
88 and 89.
88 and 89.
Petitioner state that they are educated but unemployed youth residing in state of West Bengal. My lord has not got that.
Yes.
The petitioner number 1 is a resident of Nadia district. The rest of the petitioner are resident in the area under GTA and other hill districts of West Bengal. The petitioners are well qualified to be appointed as assistant teacher in secondary level of government-aided schools in the area. Inasmuch as them that they are graduates and having training qualification, the petitioners are aggrieved by the illegal action of the respondent authorities by which vacant posts of assistant teachers in GTA area are being filled up through backdoor and thereby reducing the chances of selection of the petitioner when regular selection process takes place. Paragraph 2, only first few lines. The petitioner states that the petition number 1 always wondered as to why in every selection process for assistant teacher in the state of West Bengal, the vacancies in the district under the administration of Gorkhala and GTA were never notified. Then, my lord, kindly take the prayers. So the prayers are that they are unemployed youth, they are otherwise qualified and they seek employment in the region, field region. Now, my lord, kindly take, my lord, page 117, the prayer. Prayer A is for appointment of, my lords have got that. Prayer A is for appointment of independent agency to investigate the regularization of the teachers, the issue of regulation of the teachers. Yes. Prayer B, setting aside the regulation of all teachers after July 30, 2010. Well, that is why I wanted to place that memo.
Prayer 199.
Yes. Prayer C, issue a writ a mandamus by setting aside the letter dated March 8, 2019. Well, that I showed to your lordship. Prayer D, my lord, the set aside the list dated August 12, 2020 and other such list of persons who are sought to be regularized in the near future. Prayer E, the declaration that voluntary teachers who have been appointed in violation of Article 14 and 16 cannot be regularized. Prayer F, this is very interesting. A writ in the nature of declaration declaring that orders dated, my lord, he is challenging orders passed by the coordinate bench before this court. Then G, similar such prayer. Then my lord, then G, after G, then comes H, again, my lord.
Very good. Yes, now the persons who were sought to be terminated, they were not parties.
My lord, they were not parties. My lord, the persons, my lord, they made applications, I believe.
The page, show us page 199.
190. Yes. That is what I'm on. My lord, kindly give me 1 second. Kindly let me show your lordship page 199.
Page 199.
I take your lordship to 2 more memo because this is relevant. At para 22 of the writ petition, an undertaking was given that they would implement the parties who are going to get affected by the litigation, subject to correction. All right.
Then they were the persons now filed application for
intervention.
Yes,
they filed application. They have been added as parties, and one batch is being represented by Mr. Mujumdar.
They were allowed to file it.
Yes, they were allowed. They absolutely. Mr. Mehmet is absolutely right. Yes. My lord, kindly take page 199 because.
Lordship, may I just say one thing, Lordship?
You are for whom?
Item number 6, appellants. I was not given any documents, Lordship. That's why I have challenged that.
All right.
My lord, may I take your lordship to page 199? My lord, two more documents I have to show before your lordship. This is to bring. My lord has got that, my lords. This is to bring to the notice of the heads of the schools of primary, secondary under DGHC that henceforth no volunteer teacher shall be appointed by the schools or managing committee of the schools without written consent of the Education Department, Darjeeling, Gorkha Hill Council, Darjeeling. The lordship will find that the copies were forwarded to so and so. My lord has got that?
Yes.
Then, my lord, if your lordship kindly takes along with this one more memo. That is dated, that is at page 200. I'm sorry, page 200. Next page. This is dated 25th of June 2018. Title.
Yes.
These are decision taken by the GTA. I am directed to convey that the authority in GTA will henceforth, my lord has got that, will henceforth not entertain or allow engagement of any voluntary teachers to schools. During scrutiny, it came to notice of the authority that many cases the unauthorized engaged candidates do not possess requisite qualification or were whimsically introduced on violation of earlier order number so and so dated 30th July 2010 of the Secretary of the Education Department of DGHC. Such engagement of voluntary teachers is in contradiction to the mandate of the government of West Bengal and other appropriate authorities, henceforth will be considered as personal liability or by the head of the institution and its managing committee. Well, between this 30th July 2010 and 25th June 2010, 18, Code 39 teachers were regularized and their regularization was approved by the cabinet.
So that is between 25/6/2018 and
30th July 2010 and 25 June 2018.
30th July is that order.
DGHC's order, because the main contention, one of the main contention of the petition is that these appointments have been made in violation of the 30th July 2010 order. Then, my lord, what is most relevant is that kindly take now 28th June 2018. This your lordship will find at page 675.
Yes. Why you are showing us this?
Mala, this is why I'm showing this.
70.
Mala, 28 June, Mala, subsequent, Mala, these are the two orders which form the basis of the case of the petitioner, writ petitioner. And your lordship will find at page 675, that's a decision taken by the Board of Administration, Gorkhaland Territorial Administration, 28 June. My lord, kindly take third paragraph. I will not read the entirety, my lord. The meeting commenced with the board approving the proposal for regularization of volunteer teachers in secondary schools under GTA as a special case and which has been sent to the Department of School Education, Government of West Bengal, the order number so and so dated 30th July 2010 and my lord, the order dated 25th June 2018 shall not affect the decision of the board. So my lord, whatever has been sent, my lord, after that, no further engagement would be made. That was the whole objective of the Board of Administration GTA. Now, my lord, your lordship will find when this list of 313 was made, it is nobody's case, at least it cannot be the state case of the state or even the writ petitioner, that these 330 are different from 439 teachers whose services were regularized in 2017. It cannot be anybody's case, before your lordship. Now, my lord, now come to another memo. After that, my lord, I will just make my submissions on questions of law. Kindly come to page 674. Because much submissions have been made, that lordship has got 674, my lord. Your lordship will find on 8th March 2019, the state government decided to approve the services of the teacher, 313 teachers. On 8th March, that is on the same day, my lord, this chairman board of administrator, my lord, one must keep in mind, my lord, at least my lord, I would beseech your lordship to keep in mind that the board of administrator has been appointed, it's not an elected body at that point of time. It was, my lord, appointed by the state, and at that point of time, it was nothing but, my lord, an alter ego of the state. So on the same day, the board of administrator directed that, my lord, this DI was requested to take steps for issuance of letter of appointment and approval to 313 voluntary teachers.
Show us the commission report, committee report of 9th of October.
Yes, this is the most important thing. Compilation of
9th October.
Yes, this is very interesting. When the matter was being heard out before by the honorable single judge, the state formed a committee. And though the state had been state for the first time in the affidavit, and the committee made it known to the court for the first time that the approval which was given on 8th of March 2019 was an approval in principle, though the order does not say so. And there was no financial concurrence from the finance department. And a month later, 8th of March is the order, month later, some kind of requisition was sent regarding to the DI to estimate the financial implication. But the order dated 8th of March 2019 does not say expressly or impliedly that is an order in principle. And then, my lord, in the report, I want to read the report. kindly take the stand of the state.
Now, who has given this version that it is a in principle report?
My lord, this is the version given by the state in its affidavit, education department.
So it is a general direction.
It's a general direction according to them, according to us.
But theoretically, it cannot be implemented.
Theoretically, then, my lord, it is a, what should I say, my lord, it is nothing. It is just like, my lord, a kind of, my lord, illusion.
Then, Mr. Majumdar, if this goes on the basis of such stand of the government,
my lord, I am questioning that stand. I have questioned that stand. That report, though was made available during the hearing of an SLP, there was an order in this matter for direction CBI inquiry. That order was challenged. That order was set aside with the Honorable Supreme Court as subject to correction. And in the SLP, this report was part of the records. And in the, your lordship will find from the report, kindly take the stand of the state in the report which has been quoted in the order.
judgment.
I'm sorry, my lord. Kindly take, my lord, for once. Once again, kindly take page 673 for once.
Taken a decision to regularize.
Kindly take, my lord, 673 for once. I'm grateful to my learned junior. Kindly take, my lord, the direction. At the end of the memo, copy forwarded to kindly take serial number 5. First, my lord, 2. 1 and 2. Commissioner School Education Department to process the matter in consultation with Commissioner School Education immediately. Commissioner School Education Department, Government of West Bengal to coordinate the matter with CSE, Director of Education on priority. Then, my lord,
no, your stand is that in view of this valid decision of the state, our approval was granted. This is your stand.
Yes. And
now this has been sought to be
diluted.
This
has been, the state is taking an inconsistent position.
Now state is against you. State is saying that
I am questioning the stand.
Is the stand of the state against you now?
Absolutely against me. Absolutely against me.
What is their stand?
Their stand is that this is in principle approval. What they did, my lord, your lordship will find from
now take us to the
report. Kindly take, would your lordship go through the entire report or the quotation from the order?
Portion.
Kindly take the order. And your lordship will find the report in the order itself. Kindly take, my lord, the order at paragraph 20. I will take your lordship to some of the
memo. No, order copy to wait.
মেমোটা দিন তাহলে হয়ে যাবে
memorandum of appeal, my lord. I'm sorry, my lord. Memorandum of appeal would do.
মেমো হয়
Because, my lord, this is such a voluminous.
Yes.
মেমো থেকে দেখে নেওয়া যাবে প্যারা 20
দেখেন
My lord has got that.
প্যারা 20
Paragraph 20. 1920. Down, we have to go. I will take your lordship to the order.
Round number 20.
It's paragraph 20.
Paragraph 20 of the order.
Paragraph 19 and 20 of the order.
19.
For this report purpose.
Yes. The school education.
Yes. The school education department had constituted a committee consisting of Commissioner of School Education, Joint Secretary, Secondary Education Branch, Deputy Director, Grantinate Section, and representative of the DM Darjeeling to cause an inquiry as to how the appointment or approval of 313 candidates as mentioned by the GTA in its affidavit have allegedly been made without waiting for the final approval of the state government through Finance Department and Cabinet, as it was done in the case of appointment of 439 voluntary teachers in the year 2017. The Commissioner of School Education Department, under his letter bearing number so-and-so dated October 9, 2023, had submitted the inquiry report of the state committee before the Principal Secretary Government of West Bengal School Education Department. A copy of the said report was filed before this court, and the analysis and conclusion of the said report is quoted below, which itself would demonstrate the illegality committed in appointing the said 313 voluntary teachers in the name of regularization. But it becomes the basis of the order.
So the state stand is that the induction was illegal.
No, the state stand is that we did not give any approval. That was in principle. I'm reading out the report.
No, don't go to the, where is that line?
Kindly take.
No, but please tell us what was after this order, state memo of 8 March 2019.
Right.
What triggered the state to constitute this
The
committee?
filing of the writ petition triggered the state.
Filing
Filing of the writ petition triggered the state, nothing else.
writ petition is of 2023.
No. This report is subsequent to the filing of writ petition. Constitution of the committee is subsequent to the filing of writ petition.
So direction by the writ court, earlier writ court, there was any direction?
There was no direction. It was an action taken by the state on its own. During the pendency of this writ petition, which has now been partially disposed of. Now kindly take the first paragraph of
that report is against you.
That report is against me.
Very good. What is the ultimate conclusion?
Ultimate conclusion is that
terminate.
No, terminate.
Recommendation.
1920s holidays.
Page 170. Page 178 kindly come. Paragraph 21 top recommendation.
20 recommendation, may I just, your lordship is taking paragraph 20, right?
The quoted portion, last recommendation of
last
the committee.
recommendation is initiation of disciplinary proceedings against the DI. What happened? DI retired in the meantime. They initiated a criminal case. The criminal case was registered. At the conclusion of the inquiry or investigation, it was found out by the investigation wing, investigating agency, that it is not a case fit for filing charge sheet, so FRT was given. The learned judge says that since the matter is so serious, since a criminal case was registered against the DI, so everything should go at paragraph 21. Recorded in the order. And kindly, first one paragraph from the report I will read, then I will take your lordship to paragraph 21.
So that FRT was not revived or challenged?
Nothing. FRT is absolutely FRT.
That is accepted. That is accepted.
173.8.
No, that is accepted.
Yes, accepted.
They will accept this. Obviously, they will accept this. Everything is so scam. Anyway,
Scam is again a very interesting phenomena, which is haunting all of us in West Bengal. And my lord, I tell your lordship, in this particular, I will make my submissions now. My lord, it is very interesting. Kindly take, my lord, paragraph A. Paragraph B rather.
Page, that is.
Page I am reading from 20 only. Just paragraph B of the report. Where they admit that there is no commission. May I just read it out? It is pertinent to mention here that by an order number so and so dated 5th September 2003, the operation of the Hill Region Office of the SSC had been kept under suspension. But that did not mean that the West Bengal School Service Commission had lost its jurisdiction in the hills. Presently in the GTA area. In the hill area, the SSC can operate through its central commission. This has also been clarified by the School Education Department letter dated 4th or 7th December 2009 to inform the DI of schools AC, Darjeeling, GTA that no vacancy can be filled without the recommendation of WBSSC. Was any step, I put the question to myself, was any step taken for last 20 years by the Central School Service Commission or by any other authority to fill up any vacancy in the hill region? State cannot.
Where is that 7 December 2009 memo referred to in paragraph?
That is not with us. That is not with us. Malad, they have, but the state may be able to produce it. Right? Now, Milord,
July 2010.
Now, Milord.
Now, this report is of 2023.
Yes, subsequent to the filing of writ petition. The committee was constituted subsequent to the filing of writ petition. Report was also
very good. Now,
and that was without any order of the court. It was the state on its own did.
So, your argument, if we can understand, is that admittedly since 2003 to 2024, there was no appointment of any teacher through the commission. Absolutely. Because it was suspended.
Right.
Suspension was removed into 9th of August 1999.
No. The hill region was included as a region under the Act in 1999.
I see.
By an amendment. Then 9th August 1999. Then, my lord, after 9th August 1999, my lord, the regional commission for Hill region was established. From 2003, my lord, this particular commission, regional commission or the regional office of the commission was suspended. So, my lord, the operation was act of this SSC Act was kept in a suspended animation for last 20 years. It's a clear case of suspended animation. No, my lord, nobody can point out. Well, interesting.
And you were engaged during that interregnum of 2000,
I was not engaged. The teachers were engaged by the
2003 to 2024.
2007 to 2016. The period is like this.
2000.
But that is within that period, my lord. Within that period.
39 was from 2002-3 and the remaining 313 from 2007-8.
No, just reiterate, your engagement was during the period from 2000, their engagement was during the
313 were from 2007-8.
313 were engaged from 2007-8.
216.
216. And the 439 were from 2002-3.
No, they were from 2007. Why you're saying till 2016?
Well, there are different dates of appointment for different teachers by different schools. Well, the schools were appointing.
Now, this group, over and above this group, there were 439 volunteers.
That is what appointed from 2002-3 onwards.
By the respective schools.
By the schools. All by the schools.
So, for this 439 was from 2003 to 2003 onwards.
2-3, my lord, your lordship can take 2-3.
Acha, they have been regularized.
By the cabinet decision.
By a cabinet decision.
On 21st of February 2007. 70. I'm sorry, 70.
So, where is this cabinet decision?
The cabinet decision, we do not have. The dates are
2017, and this memo came on 8th March 2019, which state now states
when we found out that only 439
a total conundrum.
It's not a conundrum.
Total conundrum.
It's a question. When we deal with, this is a peculiar case, a peculiar facts and
No,
circumstances.
Mr. Mojumdar, you tell us why should we grant an interim?
Your lordship would grant an interim order for the reason that, my lord,
Admittedly,
91 or 92
no,
schools.
Just one question. No, that we have understood, that they are engaged in 91 schools.
And
there will be a chaotic
and
situation.
Uच्च examinations are approaching. The date of examination is 2nd February or 9th February. That everybody knows. That is within public knowledge. There is no attempt as of now. There cannot be, my lord. The state does not have that, my lord, the genie in the lamp that they will conduct the selection process within 1 month and fill up these vacancies within 1 month. They cannot do. They have not done. They will not do.
All right. This is one.
This is one aspect.
No, second, you tell us,
Yes.
8th of March 2019
Right.
memo. If this, I don't know what the learned single judge observed, if it is an in principle memo, these do not confer any right upon you, or your regularization cannot be sought for on the basis of
But
that.
that is, my lord, on the basis of the stand taken by the state subsequently.
But state itself says,
State itself, can state, take a stand contrary to its own memo, contrary to its own writing. I put the question to myself.
why contrary you are saying? It says state has taken a decision to regularize, but not implemented as yet.
Taken a decision to regularize, state cannot implement, state can only implement the decision through its agencies and officers. That is why under the head copy forwarded to, your lordship will find different senior officers of the state have been directed that you do it immediately. It's not a mere decision. Had it been an in principle decision, then, my lord, this copy forwarded would have been there. But wait, hold your horses. It's not a question of holding the horses. State had it's a peculiar case. When we
Now, very good, do it immediately. Now state takes a volte-face and states that the committee we are constituting, now see the committee report. It says, then what had been the argument on behalf of the state?
Nothing, my lord. The argument of the state is simply submitting the committee report and taking a stand contrary to its own memo. That's the argument.
In fact, in an appeal,
dump them when you like, take them when you want.
But in my
Who is for this state?
I led by learned AG, my lord. Virtually, my lord.
Yes. Very good. You have now
My lord,
kindly
yeah.
take us to the operative part
Yes,
of
ma'am.
the
Can I
order
take your
and
lordship?
what interim order you want.
My lord, kindly take. We have the details of the affected schools even. My lord, kindly, I don't want to burden your lordship
That
with
is
that.
91 schools.
99.
And
My
Madhyamik
lord,
is
kindly
on
take, my
the...
lord.
secondary and tertiary, 313 teachers in for.
My lord, may I take your lordship to?
So they are of secondary higher secondary.
Yes, yes. Again. Kindly take the order. Kindly take paragraph 16 of the order. From paragraph 16. Kindly take from paragraph 10. I will quickly run through the order.
No, it shows the relevant
My
question
relevant
because
question
Mr.
is
Bhattacharya
kindly
will
to
also be
paragraph
showing.
16. First, whether a learned honorable single judge could have done this or not. Within the scheme of the scheme of judicial committee. Kindly take paragraph 16.
Paragraph at page.
At page, my lord,
Internal
I can
page,
give a lordship the internal page, 40.
Yes.
May I just read it out? That apart, the Honorable Division Bench of this court in the case of Kiran Subba versus State of West Bengal reported in 2008 to CHN had the occasion to deal with the issue of applicability of the State Act of 1997 in respect of schools under DGHC. Well, I am not disputing that the Act applies. The Honorable Division Bench, while interpreting Section 15 of the Act of 1987 and the explanation appended thereto, has held that the provisions of the WBSSC Act, the West Bengal Board of Secondary Education Act, and all rules are obviously applicable, save and except the explanation provided in the respective acts thereof. In view of the said decision of the Honorable Division Bench, I am unable to follow the decision of the learned single judge of this court in the case of Balkrishna Limbu. Coordinate bench of this court is held that the act has become non-functional because there is no SSC. Act applies. I am not saying that the act does not apply. But for the act to apply, there has to be a commission. For the act to apply, there has to be a regional commission because section 7 of the act provides that only the regional commission can trigger the process of selection.
But if that is so, then during alleged suspension also there was regular appointment.
No.
Some persons have been given. You said that
these are all, my lord, volunteer teachers who have been appointed by orders of court. Nobody, no regular appointment during that case, during that period.
Means 2003
to 2020, even today, we are at the end of 2020.
So the persons who were similarly situated, they were also appointed in a manner on the basis of the school.
Let us take three sets. One set appointed by orders of court, maybe 100 or something like that. Another set 439 appointed by the by cabinet decision in 2017. Approved by cabinet decision, whose services were approved by cabinet.
439.
439. Another set 313. That is the present case. Same manner of appointment. Same manner of appointment, like manner the first two sets, but left out in the list of.
So order of court and the other is committee recommendation.
No, other is by the cabinet.
Cabinet approval.
Yes, cabinet.
After that long litigation, who were selected in 2002. There was selection in 2002. There was so many litigations. Ultimately, they were appointed in 2007.
Right. Mr. MS is perfectly right. But that again 2002. Not after 2003. Those are the selection process of 2002.
Very good. They were appointed. Then what happened to those appointments? Those are intact.
Those are appointments.
That is prior to 2003.
Election process said 2003.
They could not
in
join.
2003, the 97 Act operation in respect of Darjeeling Hill Council was suspended.
Kindly take now. Your lordship has gone through. In the coordinate bench has held, a bench of Justice Shane held that the act is non-functional. So far as because there is no commission.
No.
But to the best of my understanding, but whatever little I have learned from your lordships is that when a coordinate bench passes a decision which directly covers the issue in hand, then and if a different view is sought to be taken by another coordinate bench.
But this Kiran Subba is not similarly situated
Absolutely.
with you. That is what
No. Kiran Subba's case is that the SSC Act, West Bengal Board of Secondary Education Act, will apply to Hill region. I am not questioning the application of the Act to Hill region. I am pointing out before Lordship the Act was not enforced in the Hill region for the period commencing from 2003 and till 2024, because now I am told that an office has been set up, but there is no secretary. There is no secretary.
very good.
I am not saying, I have no cavil to the proposition of law or the law laid down by your lordships in Kiran Subba. I do not say.
Very good. Now,
May I continue with this order?
entirety you have not to read.
No, only that. Now take paragraph 18.
Yes.
Your lordship will find that the in principle issue was considered in paragraph 18. The stand of the state was taken note of. But this is a very strange, strange alliance, where the petitioners find ally in the state. Very strange.
Now, what is this 271 voluntary teachers?
We proposed 271, they said it is 330.
You proposed GTA.
GTA proposed it is 271. DI conducted inquiry and pointed out, no, it is not 271, it is 313.
Then what happened? Then
that 8th March memo was issued.
6th March?
8th March, I'm sorry, 8th March. I'm so sorry. That is page 673.
The decision to approve.
Very good. Then my lord, approval was given on the basis of, not only approval was given, this entire theory of in principle is not a theory which is tenable before this honorable court, because the benefits of ROPA 2019 was extended to each one of them. Each one of the 313 teachers.
That does not create any right in your favor.
That creates a
Does it enter anomalous
situation? I'm not on that.
State is said that you
I'm aware that does not what I'm on. They say that it is in principle. They say financial concurrence is necessary. When financial concurrence was not given at all, then how could the ROPA 2019 benefits could be extended to these kind of teachers? It was financial concurrence not available. So how the ROPA 2019 benefits could be extended to these 313 teachers admitted? Well, kindly take one of the ROPA order 679.
Very good. Now, show us the
order.
The court's conclusion.
Yes, court's conclusion. Your lordship will find paragraph 18. The court relies on the affidavit filed by the state. The court also notes that the financial implication was yet to be considered. That is why I am showing that ROPA extension. Then, my lord, 19, the school committee, I already placed 19 and 20. Then, my lord, kindly take paragraph 21. What finally seals the deal. The Deputy Secretary, School Education Department, on the basis of the said inquiry report and the recommendation thereto, had lodged a complaint with Vidhannagar North Police Station against the said District Inspector of Schools, AC Darjeeling, and others being Vidhannagar North, PS case number so and so. The said criminal case, though, has ended in final report, but the report of the inquiry committee and the initiation of the said criminal case certainly signify that the regulation of the engagement of these 313 voluntary teachers was done in violation of laws. So, my lord, the report, it is on this basis, these appointments have been cancelled. The report and the initiation of criminal investigation, though the criminal investigation ended in FRP.
So, this inquiry report is of 9th of October 2023.
That is subsequent to the filing of writ petition. Even the committee was constituted subsequent to the filing of writ petition. Give me the date of the committee, just 1 minute.
No, very good. Now, kindly come read the paragraph 22 first 5 lines.
Yes, I will read, man.
I am unable to accept Mr. Kaur appeared for.
Mr. Kaur. GTA.
Achha.
Man,
Yes.
I am a stepney for Mr. Kaur. He is not available now.
That the government, after extending all
I'm reading. Man. After extending all benefits of a regular teacher to the state 313 voluntary teachers, now cannot turn back and say that the approval of regulation for initial engagement of the state 313 voluntary teachers was an in principle approval pending final approval. That being the position, the decision cited by Mr. Kaur, the judgments are cited, have no manner of application in the present case. The state never took a final decision to regularize the engagement of the state 313 voluntary teachers. Moreover, there is no question that the state is attacking its own decision. In the present writ petition, or a dispute between the government department has been sought to be settled here. That being the position, the decisions of Raghava Rajagopalachari and the Chief Conservator of Forest have no application.
Now show us what were the operative part.
The operative part is, my lord, kindly take the operative part.
26. Right?
Yes.
No.
No, my lord, it is paragraph at the after 29. Page 51. Conclusion.
Yes.
Summing, my lord has got that. Summing up the discussion made above, this court holds that the appointment of 313 voluntary teachers in the name of regularization, whose particulars have been disclosed in the supplementary affidavit filed by GTA on April 29,
Yeah, just one interruption.
I'm sorry.
Your engagement was from you.
Not my engagement, man.
Those engagements were from 2007
to 16. 7 to 16. Roughly.
Yes.
Well, may I just read out? Summing up the discussion made above, the court holds that the appointment of 313 voluntary teachers in the name of regularization, whose particulars have been disclosed in the supplementary affidavit filed by GTA on April 29, 2025 is illegal. Accordingly, the impugned letter bearing number so-and-so, dated March 8, 2019, whereby and whereunder the engagements of 313 voluntary teachers were regularized by the Principal Secretary of Government of West Bengal is set aside and quashed. Well, if it is an in-principle approval, if it is not a final approval, then everything is also premature. What was the requirement of quashing that memo? Either it is in-principle approval, not a final approval, or it is a final approval, I need to quash it. Consequence, my lord, the only interim order which was passed during.
So their argument was that since it is an in principle approval,
but it was not their argument. It was state who brought out this argument during the course of hearing. It was not the argument of the petitioner.
whatever maybe, but
Yes.
ultimately they relying upon all those sequence.
Naturally,
They argued that
yes, they are.
Yes.
Yeah.
Now show us what are the other issues left to be considered.
The other issues left to be considered, 439.
That was 439.
439 approved by the cabinet on 21st February 2017. This is an artificial classification.
But this cabinet, this appointment by cabinet was not the subject matter of challenge in
Yes, everything was under challenge. I think Mr. Ahmed would agree to that. Everything was under challenge. All the appointments. Well, let us take
so all the appointment made in from
2010. Well, their prayer is from 2010. Whatever appointment has been made, you cancel that.
Now, why did they choose 2010?
Because of the DGHC memorandum. That no voluntary teacher should be appointed henceforth.
Oh, I see.
That memorandum, which was reiterated by the
page 199. Page 199.
199 and 200.
No, that embargo was made in which year? The 2010.
2010.
That embargo.
That embargo.
And this started from 2007.
But they started from 2000. Some of them. But I will be very clear to you about.
So in between.
But I have to be clear because when
embargo was from 2010.
Embargo was 2010.
But your engagement of 313 was from 2007 till 2018.
2007 to 18, 16. 7 to 18, 16.
Just now
2016. Well,
So-
I did not join issue here.
So
Not-
this engagement, what Mr. Bhattacharya will argue, suppose,
Okay.
this engagement is in derogation to page 190.
Absolutely, that is their argument. That
Yeah.
is absolutely their argument. An answer to that
So
argument.
then why you are saying that they have also challenged the cabinet decision pertaining
They have
to
not
court
challenged the
application?
cabinet decision, but they have challenged. They
This
have
is
challenged
their-
everything.
So their argument, your argument
Everything,
is,
everything. After the commencement of SSC Act, everything should go. That was their case. That was their case. Everything should go.
very good. Now what are the other connected issue left out?
But 439 is the issue left out. And my lord, coordinate bench decision whether binding or not, binding precedent or not, that is also left out. And also
No, that Kiran Subba has been said.
Kiran Subba is the judgment which the petitioners relied on to demonstrate before the court that SSC Act could apply to the region.
So
And-
that you said it application not
Yeah,
disputed,
I'm not questioning
implementation is disputed.
Implementation. So CBI inquiry is left. No? CBI inquiry is left.
CBI inquiry.
Well, that was quashed by the Supreme Court, but my lord, I believe it was remanded back.
Direction to file a report by CBI.
Right.
In which writ petition?
In this state petition.
Oh, in this writ.
Yes.
I see.
Clear report by CBI. That was challenging division bench. And there are division bench confirmed the order of senior judge. That was challenging SL. Supreme Court says this is, there is no reason assigned. Therefore, set aside. Decide afresh.
Decide means CBI investigation is not required. That is
At that
it.
stage. Says the order was without any reason. Court set aside and remanded. Open remand was made.
Where are those orders? Those are annexed.
They might be having, my lord. But I'm
So
not
then
questioning
what
that.
is the present scenario? That CBI inquiry is no longer there.
Yes.
No.
It was remanded open.
No,
issue
the
is there, but inquiry is not
single
there.
judge said that there. No,
issue is
single
there.
judge said that there should be a CBI inquiry.
So my lord, that issue has
Preliminary report was directly filed.
Oh.
CBI filed the report. And in the meantime, at order was challenging division bench confirmed. There are
So there was no initiation of CBI inquiry. So there was a preliminary report called for that was confirmed by division bench, but Supreme Court said that there is no such requirement.
No. Since the order is without any reason, so remand the.
Oh, now upon remand, was that issue ever highlighted or
No.
considered? Oh, achha, achha.
That is pending for further.
so my lord, 439 and CBI, if I'm not wrong.
And this is after
And the orders-
one part, only one prayer was taken into consideration and rest has we decided later.
I think
So
Mr.
suppose tomorrow if the court decides that no, 439 is okay, then the entire situation becomes anomalous. Today, that Mr. Bhattacharya will argue. Though you have finished, let us hear Mr. Bhattacharya. You are the persons who have been.
But if reply is required, my lord, I think.
Please come to the operative portion of the order.
But only one point, just one thing. The only interim order which was passed during the pendency of repetition is that no further appointment of voluntary teachers should be made during the pendency of the repetition. Right?
There was
In this repetition.
this was an interim order, not to regularize any further. Because during pendency of the repetition, further regulation was being done.
But the
Now there
regular-
was complaint of court has passed an interim order not to regularize any further.
So, my lord, that order, my lord, I am not opposing.
Naturally, you will. That does not give you a feather in. Yes, Mr. Mojumdar.
Please
No,
come to the conclusion.
if we hear Mr. Bhattacharya, then you can.
Try to reply to the.
Also, you tell your points. You are for these candidates.
Come to 330.
Now, give us this picture. Writ petition was filed impleading you.
No.
No. Subsequently, you
We got
intervened.
implemented. We
So,
got ourselves implemented through application.
so all 313 are involved here now. So you are appearing for those teachers.
Some of them. 121 or 131 have prepared an appeal.
And others are also represented by some other council. No?
It has not yet been filed, but they are in the process of filing that.
You are representing which respondents here?
130 to 132.
13.
Petition.
Yeah, achha, achha. You are 30 petitioner num. You are respondent num.
13 to 132.
Yes.
Now, please come to the operative portion of the order, the conclusion. But what is the necessity of passing an interim order today? Summing up the discussion, the court holds that the appointment of 313 voluntary teachers in the name of regularization, whose particulars have been disclosed in the supplementary affidavit, is illegal. Accordingly, the impugned letter number so dated 8 March 2019, whereby and whereunder the engagement of 313 voluntary teachers were regularized by the principal secretary, is set aside and quashed. But the court proceeds on the basis that this is not a case of regularization, but a case of fresh appointment.
That is your argument.
No, that's not what the. Please come to paragraph 10 of the judgment. The court holds it to be a case of fresh appointment. Please come to paragraph 10 of the judgment.
So the court's mind was that these persons who have been appointed shall not be regularized.
But one is, what was 8 March 2019 purporting to?
Your appointment is bad, so court said that don't regularize.
We were appointed, that has not been set aside. We were appointed long back from 2007.
How can the different dates of appointment can be chosen up and then court will say.
Regularization is of course prospective, it's not going back to an anterior date.
If the regularization goes, your engagement
No,
goes.
please come to not the order first. And it is not the exercise which was undertaken, 2 documents I shall just immediately show to your lordship.
So your argument is that regularization has been set. You set aside regularization.
So we go back to the status of voluntary teachers, drawing a consolidated remuneration of 2,000 to 3,000 rupees per month.
No, you are drawing a regular employee.
Now, what is the impact of this order of setting aside the regularization?
Impact is that you go back and enjoy salary which is to be given by the respective schools.
That consolidated amount of 1,000 or 2,000 rupees. Now please come to 2 documents at pages 360 and 363 in my volume 3.
360 and 363 is the.
It's in my sheet. Item number 8.
No, what is the. What is the document? Tell us now.
That was the factor which was taken into consideration consciously before directing regularization. Regularization in service is not a foreign concept. The 2 points were made in the writ petition. 1, we had been appointed through a procedure not in accordance with law, number 1. And number 2, we did not possess the requisite qualification. Now, these were the 2 foundational bases for challenging these appointments. But as of today, everybody is qualified. I shall refer to the government order in this regard.
As per plan. Yes, 260.
360.
What is your showing?
Now, this is not the data dated 24th of April 2018.
2nd July 28th.
So,
Page 363.
360. Not your Lordship are probably looking at the Mr. Abrodo showing the please take not
No, Shugan Vishwakarma.
please come to 360, not the pagination within brackets. Volume 3, page 360. Okay.
360, 24 for 2018.
I'm grateful. It's Assistant Secretary to the Government of West Bengal in the School Education Department writing to the DI of schools in Kalimpong and Darjeeling. The undersigned is directed to inform that a proposal has been received in the department for regularization of 271 volunteer teachers said to be serving in different government-aided and government-sponsored schools in GTA areas list enclosed. It is now requested to cause verification of the claim for regularization of these persons on the following criteria. 1. 3 years teaching experience. 2. Possession of requisite qualification. C. Knowledge of Nepali. D. Knowledge of relevant subjects. E. Letters of engagement by concerned school. F. Existence of sanctioned vacancies.
So these were the criteria laid
These were
down.
the criteria which were to be verified by the concerned department before finalizing this regularization. And which one of these factors will your lordships find is defying any law?
In defining,
None of these factors is defying a law of regularization. These are the essential factors.
so naturally, if question of existence of sanction post ought to have been there.
That's there.
Then
That's please come to now page 361. These were there. Now please come to page 361.
GTA
Yes, the administration. No, that 30th July 2010, which had been tormenting your lordships, that was not to be given effect to any further.
where you
But the third paragraph on that page 361. The meeting commenced with the board approving the proposal for regularization of volunteer teachers in secondary schools, a special case which has already been sent to the Department of School Education, Government of West Bengal. The order dated 30th July 2010 and order number of 25th June 2018 shall not affect the decision of the board.
So how does that help?
So the 2010 embargo was lifted. Insofar as regularization of those already appointed teachers are concerned.
According to, is it a relaxation of the embargo? So if your submission is submitted, accepted, it is a relaxation.
It's a relaxation. So the complete embargo which was once imposed was relaxed in 2018. And this exercise of regularization was to be done on the anvil of page 361, wherein the factors were adumbrated.
Yes.
Now, please have a look at 363. DI writing to the government, DI of course is a person on deputation in terms of the provisions of the GTA.
Very good, Mr. We understood.
As per instruction, the voluntary teachers of the government aided and government sponsored schools have been physically verified by the DI of schools, GTA Darjeeling, along with GTA representatives on their school premises by considering all criteria laid down in your letter of 24th April 2018. The said list is being forwarded to your good office for your kind perusal and taking necessary steps for regularization of the volunteer teachers, considering the necessity of the teachers and schools.
So this 271 is amongst 330.
Now, this list was ultimately found to be 313 on physical inspection and applying the criteria at page 360.
Where do we find that?
No, that's in the 313 list. No, that's your lordship will be pleased to find. Please come to page 365.
Yes.
Same day. After careful consideration and deliberation of the letter of so and so, from the Principal Secretary School Education Department, you are hereby directed to issue necessary order on 4 issues mentioned above. Letter of appointment or approval to the 313 voluntary teachers in secondary higher secondary schools who were found eligible after strong departmental verification, whose lists are enclosed herewith. Appointment or approval letter to 59 volunteer teachers of upper primary schools whose lists are enclosed therewith, to take necessary action to approve the recognition of 14 schools whose lists are enclosed therewith, in issuing of appointment or approval letter to the 4 teachers whose recommendation letter has been revoked. The entire exercise undertaken in 8 March 2019 has been set aside.
All right. Now,
I just showed you the stand of the state government. Now, there had been vacillating stand. Now, please come to only 2 documents. Please come to page 535. It's the 4th volume.
of your matter.
Okay. But within first bracket, pagination is 535.
This affidavit of state.
Yes. But in a review application before a division bench in another matter, this was the stand taken.
Review
In
application.
some other matter which went up not from single bench order, but this is the stand taken by state.
Against the some other. Yes.
That's internal page 9 of that.
So this is not their stand here.
Not the stand here. But I just showed not what is the stand. Please
Then
come.
no, state said that this is their stand.
Yes, please come to 535, paragraph 11.
Yes.
It is apparent from the notification of 1st October 2012 passed by the Department of Education that the GTA, being an autonomous body, has administrative control over the government and non-government state-aided schools. Thus, it is the GTA that has the jurisdiction to consider the representation made by the petitioner for being appointed as the headmaster of the Darjeeling Hindi High School of so and so. From paragraph 16. It is submitted that the Honorable Judge fell into error apparent on the face of the record in delivering the judgment and order dated 20th November, inasmuch as the Honorable Judge did not consider that after ceding all its powers in favor of GTA by the notification dated 1st October 2012, the applicant number 2 or any other official of the School Education Department of the Government of West Bengal do not have any authority in connection with the service conditions of the petitioner. And that's exactly not the purport of section 26 of the GTA Act 2011.
So you are saying now the memo of this 8th of March 29 is inconsequential.
The 8th of March 29 is directing
2019.
regularization.
Huh?
Is directing regularization.
Yes. That is because state, if they do not have the power to undertake that issue, as per their stand, it is for the GTA to
It's not subject to the law says subject to approval or order of the government. That's the language in section 26 of the GTA Act 2011. Now, but ultimately the fund comes from the government.
Ultimately, so how can the state say that it is no longer my child, it is your child?
Not from man to man, door to door verification. That's not safe, not our court's employees. But when a requisition is sent by the court administration to the government,
that is hard, whether those are factual issues.
Yes, those are factual issues. Not that is why I argued before the Honorable Single Judge that although the School Service Commission Act may apply to the territory of the Hill region under GTA, but going by the specific provisions of the 1997 Act, this will not apply to these particular schools.
Why?
Please have a look at section 15 of the Act.
The definition of school.
No, definition of school has something else. Section 15 specifically excludes certain categories of persons and schools from the purview of the Act.
So then if you exclude yourself from that purview, then how do you get revisional benefits of the state if the GTA has not?
One is applicability of SSC, not on two grounds, not this was argued by the petitioners. One, procedure was not followed. Number two, eligibility. As of today, eligibility is there. In fact, ROPA 2019 takes care of this eligibility clause. One who had not obtained B.Ed training at a particular point of time has been given 5 years relaxation for the purpose of obtention. Non-fulfilling this program entails certain loss of incremental benefits. That's nothing more. Now, so far as that other aspect is concerned, I shall argue at the final stage. Subbarao does not answer that question. Kiran Subbarao's judgment does not answer that question. It was on the perspective of applicability of linguistic minority vis-a-vis the SSC Act, but not in the final hearing. Today the situation is a situation.
No, I didn't follow your argument that it is from the affidavit which you have showed just now.
Yes.
535. The stand of the state is what? Your stand of the state is I don't have anything to do.
In principle approval is granted.
In principle approval is granted. Now you pick up who are the persons competent.
Now you find out the persons who are competent. Now, not this threadbare exercise carried out by the GTA to the deputy person on deputation from the state government.
But what do you say about this? The 2019 decision of government was not approved by the cabinet. It is still kept in abeyance.
Please have a look at. That's why I showed to your lordship pages 361 and 363 as well.
Yes.
But those are documents from the government itself.
No, very good. Government has said that you find out those persons.
Please come to 360.
Whether they are sanction point.
First is not laying down the criteria.
All right, Mr. Mrinder. Now let us hear Mr. Bhattacharya. In reply, if you want to give it. Yes, Mr.
I'm not
Bhattacharya.
first and foremost. Not who are the first and foremost question is not who are the persons challenging these appointments. None of them was qualified in terms of this memo of 2018.
2018 memo means
360, page 360.
which you 360 which you showed.
Not one is a student.
15 persons came.
Yes.
15 writ petitioners.
Most of them were not qualified in 2018 even. Some of them has completed his graduation in 2021.
360.
360. These were the qualification.
3 years experience.
Yes. One comes from Nodia. One is a student.
Your engagement was last in 2016.
Yes.
From 7 to 16. And you are in secondary school. So you should be graduate. So you should be graduate with B.Ed.
Yes.
You don't have B.Ed.
As of date, we all of us have.
313 has B.Ed.
Now please come to your lordships were questioning about the phases of recruitment or regularization. I think that's a summation at page 383 of my brief.
Yes.
383.
383.
What is that?
The 29th of April 2024.
Yes.
This is to bring to your kind notice that a detailed exercise needs to be done to gather information along with supportive documents of teachers whose services had been regularized in different secondary schools, both in DGHC and GTA periods, as instructed by the authority of the GTA. The information may be required in the subsequent stages of hearing of WPA number so and so. This is for your information that a report has been obtained that reveals that the services of the numbers of teachers had been regularized through DGHC as well as GTA period as follows. 2010, 42. 2011, 107. 2012, 269 plus 11 volunteer teachers. 2017, 16 volunteer. 2017, 302 plus 137, 439. 2019, 313 volunteer plus 59 new set of schools plus 129 ad hoc.
So this does not refer to the 2000 memo that which has the 8th March memo of 2019.
The last one, 2019, 313 volunteer.
Achha. So what is your contention?
But this is how not we serial number 5, 6 stand on the same pedestal as the persons in 2010.
Those who were approved by the cabinet.
Yes, same process.
Yes, Mr. Bhatt.
Not only to show that 2016 recruitment process excluded Hill region.
Yes. We take to another day. Yes, Mr. Bhattacharya.
We are at the stage of consideration of interim order. The fundamental question, I am not going to trouble my lord with the facts at this stage. Would the rule of law prevail? Would the constitutional provision prevail? Or somebody's whims will prevail? How could these people come into service? What is the source of their recruitment? Kindly go to the source. They were allegedly all voluntary teachers appointed by some of the school managing committee. Was there any application invited that volunteer teachers would be appointed? If you please come and join. There lies this question of scam. Scam is not just a mere word. And these teachers who entered through a completely illegal backdoor method are now being sought to be regularized by the state. Can the state regularize this? All these questions, School Service Commission, these are all secondary issue. Primary issue is if they are fast entry as teacher, so-called voluntary cheaters, is in violation of basic principles of law. State cannot, regularize them. GTA is not, beyond statutory provision. That's why state ultimately had to say these appointments are illegal. We cannot approve this. Advocate General.
Where has that been stated? Illegal appointment by?
That's the proceedings. Advocate General appeared, and that is recorded, I believe. I am handicapped because all the papers are not with me. That's why state had lodged a criminal complaint against his own officers. Whether that ultimately comes to a final report or not, that's a different issue, and the investigation has been directed by the court to continue. If the original source is vitiated by law, subsequent regularization by the state or the GTA is not permissible. Public fund cannot be utilized by any means for an illegal purpose. Now, at this stage, the question might come, the sentiment might be arose saying that what would happen to students? Now these schools are on holidays. Let the main appeal be taken up after reopening. On the first day, I am prepared to argue the matter in detail to show how these illegalities have been committed. Now these schools are closed. For these 7 or 10 days, nobody is going to suffer. And even if your lordship may please to consider, if necessary, GTA or the government can appoint the retired teachers who are regular teachers, their services can be explored for the students' benefit. But not allow these illegal appointees to continue, which avoid ab initio. I'll kindly fix it up on the reopening date, any date which suits your lordship's convenience. I shall attend physically and show the facts which are obnoxious facts. And another 436 if it is taken up, all will be disallowed by the court. Court by no imagination can allow the illegal appointments at the entry point. Regularization means you are regularizing somebody who had initially appointed legally, but maybe through irregular process. But everything is illegal. Umadevi is staring at our face.
So one question, Mr. Bhattacharya, the court says that for the time being, I am setting aside this memo and the other issues I will decide later. Now, today, today, Mr. Bhattacharya, if after deciding, if we say we are not interfering, in that case, what happens to the writ petition pertaining to the other employees who are still subsisting?
That was considered, not considered by the court on the prayer of the parties. The prayer of the parties was kindly that 313 appointments were being considered, therefore let it be confined to 313.
Mr. Bhattacharya, if we accept your contention, then this direction is untouched. If this direction is untouched, and after reopening the matter is heard pertaining to the other issues which include an issue of appointment of the further teachers who are done, then in that case, the same bench, how they will be tackling, then it is a decision which is remaining those issues pending. I am saying that the parent order is bad. But in that case, what remains to be decided in that?
Nothing, to me, nothing remains. Your lordship is right. But this 313 is not dependent on 436. This is not the case that 436
but
has
Mr.
been done.
Your challenge against those 436 also remains. Is of identical issues. That there was no post backdoor appointment inducted.
Right.
So today, Mr. Bhattacharya, this is upheld. Then what remains to be decided in the other round of litigation before this?
Legally nothing, but factual aspects should be there. They might come out with the different facts. But legally, your lordship is 100% right that this principle will equally apply so far the 436 is concerned. But staying at this stage would be without giving premier to the illegalities. My lord, we will not kindly give any premier to illegalities. This is creating very bad precedent for the society.
No,
let the appeal be heard out. On merit, let us see what happens.
But today, if it is left untouched, their service goes.
They have to go. But they, by allowing them to continue by virtue of interim order after a proper adjudication would give them the premium.
Then you should have said that you decide everything together. Don't make compartmentalized.
We have, well, that was our prayer. That is our prayer. That was our prayer.
No.
But
I suppose in the another appeal, one order of 2nd December has been challenged, wherein the application was for maintainability of the writ petition itself.
Yes,
that issue has also been kept open.
No, that was decided.
No, maintainability issue was not decided.
It has been decided. It's thoroughly decided.
That 313 has to be decided first.
Everything has been decided.
Maintainability has been decided.
No.
Yes.
Lordship, may I submit?
It has been decided.
Yes or no? So is that point?
Filed an maintainability application.
Who are you?
Lordship, I am the appellant in MAT
Teacher.
106.
Teacher.
Two teachers. Two voluntary
One of the
teachers.
313 teachers.
One of the 313 teachers, Lordship, who has made an application
For maintainability.
for addition of parties, seeing Lordship the paper reporting. In paper, Lordship, 300.
They're very good. Now maintainability point, where from it comes?
I have made an application, Lordship. It was never heard on 2nd.
No, this is not.
Please, let me complete.
Yes.
Don't mislead the court.
I will be showing documents, sir. On 2nd December, Lordship, while rejecting my chance to reply, it was held that the maintainability application will be decided at the time of final disposal.
Show us that line.
Lordship.
We appealed her, we ordered her. That order must be here also.
Lordship. Lordship.
Mr. Bhattacharya made submissions. This has to be decided first.
Yes, 2nd December order where issue raised in the application.
Lordship. Lordship, page 132 is the Lordship order dated 2nd December, Lordship. Lordship, in page 130. My application, Lordship, it's. Lordship.
এটার আগে হ্যাঁ ঠিকই বের করেছে এটার আগে কথাটা বলবো এর আগে ওইখানে এই যে পণ্যটাকে দেখতে হবে তাহলে
2nd December 2025, Lordship. Running page 2, Lordship.
সেকেন্ড পিটিশন এই যে এটা করেছিল
2nd December.
Should India will be considered.
And Lordship, kindly come to the last. Lordship, kindly come to the last line of the Lordship. Lordship, kindly come to the
different tinted department. Those who are appointed by orders of সেই জন্য প্রিয়ার যে ওই অর্ডার গুলো দেয় মানে ফাইলিং অ্যাপিল হ্যাঁ এবং 439 হচ্ছে অ্যাপ্রুভ বাই ক্যাবিনেট দ্যাট ইজ অলসো দেয় হ্যাঁ 313 is cabinet neither
And Lordship, last line of the final judgment, Lordship. The connected application being CAM 6 2025 filed by the respondent number 7 and 8 are dismissed without any order as to cause. Lordship, I was not permitted to place this CAM 6.
What was your all those grievances? You have to go back to the single judge. What we are wanting to know is CAN 6 of 2025 was the application for maintainability.
Challenging maintainability, Lordship. Filed on 23rd September 2025. Lordship, it was never heard. It appeared all throughout the length and breadth of the matter, Lordship.
So why didn't you tell the court?
Lordship, I told. Lordship, kindly look at the 2nd December order, Lordship. The 2nd December, Lordship was pleased to record that this matter will be decided at the final disposal.
The maintainability point was kept open.
Open initially, Lordship, on 2nd December.
Yes.
But on 17th December, without any discussion, this CAM 6 are dismissed without any order as to cause, without any discussion, without giving me any chance to make. And Lordship, one thing, Lordship, kindly go through, Lordship, prayer B of the petition, Lordship. It is not only in case this 439 and 311. Lordship, the chart, Lordship, just shown, Lordship, in 86 of the earlier.
You were also within this 313.
13. Lordship, my submission is, Lordship, prayer P of the writ petition, Lordship.
Yes.
Lordship, it says anybody whose service has been regularized post 30th July 2010 shall be set aside. Now, Lordship, then all these persons are required to be made parties. Lordship, they have only 313 has been, Lordship, notified.
ওই রিট পিটিশনটা করতে যাবে আচ্ছা, রিট পিটিশনের কপি এখন অ্যানেক্স করছে পেজ ওই এই জিটি এর অ্যাপিলে পেজ
Page 117
117
of Melodic 7, item number 7. GTA appeal.
Lordship, prayer B, Lordship, at 117, Lordship, it says, issue a writ, such and such, Lordship, by setting aside regularization of all teachers who have been appointed after July 30, 2010 in GTA areas. Lordship, they have not been made parties. Lordship, it was one of my points, Lordship, in this maintainability, in my challenge to the maintainability petition. Lordship, in the ordered sheet, Lordship, learned Honorable Justice has communicated to only 313 voluntary teachers. There was an order, Lordship, where the GTA was directed to communicate to only these 313.
You are concerned about your employment or you are concerned about others' employment?
Lordship, I am concerned that out of
You have been implemented.
out of all these things, why I should be selectively targeted?
That is an issue of 313, which has been argued. You are falling within 313.
Yes, but I am also,
You have been allowed.
Lordship,
So what maintainability you learn?
Lordship, I have so many, Lordship, my maintainability petition, Lordship, it is not dependent.
No, you are saying that those other persons, my friends of mine, are not engaged here. So how they will get information? Then the entire
Lordship, what I say,
that
Lordship,
argument is not acceptable.
Lordship, that Lordship, maybe I have to substantiate in the single bench, Lordship.
No. This is your grievance is related to your appointment, and your grievance is related to your friends who have coming within 313. So how if the 434 and others not added, or whoever had been appointed in derogation of 30th July, unless you include them, then no writ petition can be filed in High Court.
Lordship, I have found, Lordship, some of the case laws.
All right. Now, please tell us what is the stand of the state. What is your stand?
Led by Learned AG, my lord, is appearing virtually, my lord.
Where is Mr. Reggie?
Mr. Dotto, my lord. But Mr. Dotto is on leg, my lord, in a continuing matter, my lord. But my lord, with the permission of my learned senior, my lord, there, my lord, if I may submit this, my lord. So the stand of the state, my lord, as far as the interim order is concerned, my lord, the matter requires, my lord, an extensive hearing because all the affidavits are there, my lord, on your lordship's record, my lord. So, my lord, to tie to the situation as far as...
Are you supporting their engagement or you are not supporting their engagement?
No, my lord, the stand, my lord, I'll have to show from the affidavit, my lord. It's clearly
No,
written.
we are asking you a question. What is your stand?
I'll tell you, Lord. As per my affidavit, which we have filed before the Honorable Single Judge, my lord, we were contemplating regularizing the 313 volunteer teachers. We had sent a letter, which was one of the impugned letters, which has been set aside by the Honorable Single Judge, 8th of March 2019. This letter, according to us, was only an in-principle approval awaiting the decision by the cabinet. My lord, your lordship has found, my lord, already, my lord, as my learned seniors have submitted for all the parties, there were earlier rounds of regularization also, which has been approved by the cabinet. As far as this last batch of 313 was concerned, the approval of the cabinet was still awaited. But we cannot shy away from the factual situation that we had contemplated a decision to be taken by the cabinet as far as the approval of this, as far as regularization of the 313 teachers are concerned. That is one. Number two, why did we contemplate at all? Because, my lord, contemporaneously, and even when this particular matter was pending before the Honorable Single Judge, coordinate benches and earlier coordinate benches have all directed the state to regularize the appointment of the volunteer teachers. All those orders, my lord, which has been given by this Honorable Court, have been annexed to our affidavit in opposition, where we wanted to demonstrate that the contemplation of the state is not something that we have not been earlier directed by the Honorable Court itself. Even when the matter was pending before the Honorable Single Judge in the Jalpaiguri Circuit Bench, my lord, we were directed to regularize certain teachers.
We are asking a simple question. We are asking that if your contemplation and everything goes, what is your stand? That are you beside the teachers, or you are saying that you send them home, they are not required in service because it is a backdoor appointment? You are the state. You are still feeding the teachers by sanctioning grants.
But not through the education department. That is a separate.
Mr. Bandyopadhyay, today the salaries which they are getting, can you say that the state has no part to play in that?
I cannot
Certainly
say
they
that.
have.
No, but
So
the factual, your lordship will kindly hear me on the factual situation. Unlike other teachers, where the payment is made from the education department itself. As far as GTA is concerned, it is a consolidated grant made to GTA by the Home and Hill Affairs department. It is not through the education department.
So when your home and hill, so when your home and hill department is giving the money, this consolidated fund, one hand you give the money and next hand you say, I am not acting in principle. I made a general declaration, I am not going by it. So you yourself are following a dubious process. State itself is not sure.
Where the consolidated fund is being apportioned, it is not that we are apportioning it and giving it, saying that you pay the 313 volunteer teachers. It's a different process as far as the GTA area is concerned.
So we are questioning you. We will note it in the order that either you support or you do not support. You cannot take any middle path. That I am there, I am contemplating. What is your stand? What is your stand? Tell us. I will stop the salary from tomorrow.
But may I show one sentence from my affidavit, if your lordship permits me?
You are not answering our query, Mr. Bandhu.
The answer is in the affidavit. Kindly takes one sentence from the
anticipating that what I will say.
Page 322. Kindly takes volume 3, page 322.
Yes, tell us what is that. 322.
322, paragraph 9. It is our stand there that I state at the cost of 322 of the item number 7.
Baba, it bait could be 300 and এটা সব মিলিয়ে যাচ্ছে এটা ওই এই ম্যাটারটা 7 এর আইটেম নাম্বার 7 এর 332 you said
322.
না ওটা জিটিএ ওটাতে থাকবে না এই যে
110 MAT 110
paragraph 9
paragraph 9 paragraph 9
yes yes what you are saying
kindly takes the sentence from the 4th line from the top 322 volume 3 para 9. I state at the cost of repetition that the answering respondent number 1 had communicated their intention to regularize the service of 313 volunteer teachers against the physically verified list of 313 volunteer teachers by DI by Representative so-and-so, subject to the receipt of evaluation and financial implication to be received from the Commissioner of School Education. However, since such impact assessment report was still awaited, any appointment made by the DI Darjeeling without the consent and or knowledge of the answering respondent number 1 is the onus of the DI Darjeeling, since the DI of School Darjeeling was well aware of the fact that the letter dated 8th of March 2019 issued by the School Education Department was not in the nature of final approval, as would be evident from the communication dated so-and-so issued by the DI Darjeeling. Then the answering respondent is not in a position to provide the details of so-and-so. This is our exact stand, that it was awaiting a cabinet approval. Allow করেছো? My lord, your lordship's court officer may also allow Miss Learned Advocate General to join, my lord. He has already applied to join, my lord. And my lord, secondly,
Yes, you are.
irrespective of this part, we had also taken a point of locus of the writ petitioners. My lord, that point, my lord, since it was being discussed, my lord, that point has been decided by
Yes,
the
where is the Advocate General? Put him in online. Where is your Advocate General? Has he joined?
He has applied to join, my lord. He has applied to join.
So he has applied there and he has then applied to you, then tell the court.
My lord, he was on legs. Before your lordship's neighboring court, my lord, he was on legs, my lord. Join করেছো?
This is what Mr. Dotto will also submit. I think you must have it.
He may,
Where is
my lord, he is.
We don't find him.
My lord, the court officer has to allow him to join, my lord.
না না, আমার গলা পাওয়া যাচ্ছে, গলা পাওয়া যাচ্ছে।
He has been allowed.
এই তো,
লিংকের প্রবলেম হচ্ছে নাকি?
কোনো প্রবলেম না। Yes, Mr. Dotto.
But I'm sorry, my lord.
No, you first ask from Mr. Bandyopadhyay what he has submitted. Now he
Yes,
will
sir. What he has
submit.
submitted has been recorded by the learned single judge, my lord, in page 12 of the order under appeal. Please have please come page 12, subparagraph Roman 4.
No, internal page.
Yes, page 12.
Roman 4, kindly have a look.
Yes.
His lordship was recording the submissions for the state. Roman 4 says the state is expressly denying allegations of illegal appointments, opaque or arbitrary selection, nepotism or favoritism, corruption or abuse of authority, wrongful backdoor entry in regularizing the engagement of the voluntary teachers. The letter dated 8th of March was an in-principle approval awaiting final approval. The said letter clearly demonstrates that the Chairman Board of Administration GTA was directed to approve the matter in consultation with the Commissioner of School Education, who would coordinate with the Director of School Education. The state came to know of the appointments for the affidavit filed by the GTA in a connected matter, which was withdrawn subsequently. Then kindly take back the Roman 5. No illegal list was prepared, no clandestine process was adopted, no large-scale regularization had occurred, and no appointments were made without procedural examination. The state in its affidavit has relied on various orders of the Honorable High Court by which directions were passed to approve the appointments of voluntary teachers from time to time, and some similar orders have been passed during the pendency of the writ petitions. Therefore, the state action in granting in-principle approval is in similar line as directed by the Honorable Court in various writ petitions cutting across more than last decade. It is impossible, so and so. Now, my lord, 2 or 3 documents, my lord, the lordships may kindly have a look. The first, my lord, I would be, my lord, referring to, my lord, the appeal filed by GTA. I have the copy of that appeal with me.
Oh, Mr. Dotto, we got your answer. We are passing our orders. Anything, we have heard them extensively, Mr. Dotto.
We had a point of focus. I believe the lordship would be hearing those at the time of final hearing.
With or without an interim order, that we will decide.
Yes, that is for your lordships to consider. But the only thing that I can.
কালকে অর্ডারটা দেওয়ার বলছে কি করে তখন কি হয় কালকে রাখতেই হবে অথবা দুটোর সময় রাখতে হবে
দুটোর সময় কি সিঙ্গেল বেঞ্চে
সিঙ্গেল বেঞ্চ কি করে দুটোর সময় রেখে দিন তাহলে তো হ্যাঁ দুটোর সময় অর্ডারটা দেওয়ার জন্য রাখা সেটাই বলছি আপনি কি অসুবিধা আমি চাইছি বাড়ি গিয়ে কথাবার্তা বললেন
May I just add one line, lordship? In my map 106 lordship, the pressure is total. I have lordship shown that my clients were not given the documents lordship on which lordship I am to rely on. So, Lordship, this order, Lordship, may not bind, Lordship, this applicant, Lordship. Matt, one.
No, we will take up those three, all the three matters we are taking up together. We'll pass out.
Lordship, my contention, Lordship, in 106 was that, Lordship, my client didn't get the documents, Lordship, upon which, Lordship, he can answer.
We pass our orders tomorrow, Mr. Bhattacharya. We have to. It will be the first matter tomorrow. We will pass our orders.
Give the oblige.
Hard learned.
Before your lordship's rise, my lord.
We will just pass the because 2 p.m. we have a bench. Within 15 minutes, I don't think it will be possible.
Our presence may not be required.
Tell your juniors to be present if necessary for clarification.
No, we have heard Mr. Bhattacharya, Mr. Shamim, and all we have heard. We will not be inviting further argument. We will pass our order. কালকে 10:30 সময় ফিক্স করে দেব। Thank you, sir.
Could I not take this indulgence, my lord, to mention item number 14?
No indulgence.
The problem is, my lord, I'll be very, my lord, with apology, my lord, may I make this submission?
Take your lordship kindly, man.
Yeah, just order that লিখে দাও। All the above appeals are. All the above appeals involves identical questions of law, questions of law, and identical questions of law. And as such, the same are taken up for analogous hearing. No. What are you against second? Your appeal is against 2nd December order. The appeals are taken up for hearing, analogous hearing. Hardly learned advocates appearing for the respective parties. Stop. List the matter as for orders in the daily supplementary list of this court on 23 তারিখ on 24th.
But so far as item number 14 is concerned, will not kindly give me this indulgence.
Mr. Dotto, we cannot take it up just.
Well, only thing, Millard, what has happened, Millard, may I only inform the appeal court, Millard, where the matter is appearing, Millard, before the learned single judge today. It was called on about 10 minutes back. But I requested the learned single judge not to take up the matter because the appeal is pending. Where the learned single judge overrules my objection. I said that if you pass any further orders, my appeal would become infructuous. Recording that, Millard, the learned single judge passes further orders. Now, where am I to go? Well, I cannot regulate the court's proceeding. Now,
So
please
where is
consider
the-
this, Millard.
Who
Even
is
the-
your other side here?
Mr. Vikas Ranjan Bhattacharya is appealing for the petitioner in that matter also.
Yes, I'm there for the petitioner.
But how could it be?
Didn't pass any
this is
order
with
which might
respect,
affect the
Millard.
pending appeal.
Millard, this is with respect, Millard,
With
judicial
the best of
indiscipline.
respect, Learned Advocate General has misled himself. Learned Court did not pass any order which will affect the pending appeal in any
No.
manner.
Millard, the learned single judge has called for records of an inquiry to
That
pass
doesn't
further
relate to the
orders.
appeal. That doesn't
The
relate to the
learned single
appeal.
judge says,
তাড়াতাড়ি বল,
I
মামলা
will
তো
record the matter, but I will pass an injunction.
So order has been passed. No?
These are, Millard, some unpalatable comments, Millard, which, Millard, does not go with the traditions of our
No,
of our court.
Mr. Dotto, what ultimately the single judge has done?
Millard, the learned
Only-
single judge has called for
Passed a
Millard,
fresh order.
Passed a fresh order. Fresh order.
What is the order? Then we have to go into it, Mr. Now the matter has been kept.
Please keep it, Millard, as the first matter tomorrow. I can understand, Millard, your lordships have many other business, but Millard, my appeal cannot be made infructuous in this manner. Please take it up as the first matter tomorrow, again, Millard, subject to the business permitting. I
So
cannot,
first we will
Millard,
pass orders on this. We have to
Very
pass orders on this. Thereafter, if time. When is the next date fixed by the learned judge?
tomorrow. Again tomorrow.
Otherwise, might it would become infructuous.
No order
Because
has
the
been
state
passed.
has
Millard,
many
Millard,
machineries. They prefer appeal
how
from
can- how
each and
can
every
a-
order. My appeal would become
But
infructuous.
only passed over has been done, but today the matter has been passed over to
No, it has
enable the
not been passed
authority,
over. Mr. Shamim Ahmed,
enable the
Mr.
authority
Shamim
to
Ahmed will kindly
produce.
not
All
mislead
right,
the court.
Mr. Both of you are here. We will keep it as the second matter after this
After,
three.
yes.
But only this understanding, kindly, my lord, Mr. Bhattacharya is here. We have great respect for him. If, my lord, by the time your lordship takes up this matter, if the single bench matter is called on, my lord, we'll jointly pray for an
No,
adjournment.
that's why
before
that's the plan to correct the facts, my lord.
Well,
The matter has been passed over
Singhal ji,
today.
Mr. Dotto, you submit. We have completed.
this is
we have to
unfortunate that
pass
some
the
My lord, we have
anticipation
made
against the
this
judge.
submission. My
Very
lord,
unfortunate.
my lord, if this submission is overruled by the
This
court,
is something aspersion of the
what
court.
can I do?
এটাকে উপরে উঠিয়ে দিয়ে আছে আইটেম নাম্বার
1-4.
Item number 4.
আইটেম নাম্বার 14 টাকে তুমি এই তিনটে অর্ডারের ম্যাটারের পরে
I am grateful.
give it is it not sufficient?
Just a day. I will. Your notes not officers. 11 one shot. Two officer will come to call. Counter one.
Fortunately, this is happening always in these recruitment cases.
Lordship, before you rising, Lordship may kindly take up the item number 10 as there is some urgency.
Item now that securitization matter.
Lordship.
It will be there. Which is your item?
10.
Item number 9. Item number 9.
Item number
Item number 9, Lordship.
ওটার পরে রেখে দিন
Lordship, deeply obliged.